right? Okay, so let's come back to the lecture 4, issues with lawmaking bodies in the Pacific. It's not going to be very long, but I really want you to, I mean, it's very important that you guys read the study, the topic guide, sorry. Everything is in the topic guide. Sometimes, this is a summary of the topic guide, but sometimes, of course, sometimes there are some additional things, but if you read through the topic guide, you guys are good. You will be fine. But if you don't read through the topic guide, you will have problems. I can guarantee you will have problems because some of the theories we are going to discuss, you will only know, know the details and the principles and what the difference between each theory if you go through the topic guides. And it's important. For example, when we talk about the legitimacy of the rule of law, there's a theory, a number of theories, they have developed this, and also the difference between good values, the values of the civil society and the values of the, what's the thing? We're going to look at it again. Civil society, and the other one is, can't remember the name exactly. But we are going to cover this. You need to know the difference between the theories. The main one, especially because we are going to, I'm going to cover this in the final exam. Oftentimes, in the final exam, there are questions on the different theories. I may, for example, in the final exam, I may only mention in one question the name of the theorist, and then you need to explain to me, identify and explain what is the theory about, and also talk about the values or the principle of this theory. So I may give you the name of the author, and then you need to identify, okay, so this author has developed this specific theory, and what's the definition, and what's the main idea behind the theory, etc. Okay? So my point is, you guys need to also read the topic guides. Otherwise, you will be in problem. Okay, so today we are going to talk about the legitimacy of the rule of law, and also see some of the theories underpinning, this idea of legitimacy of the rule of law. We're going to talk about the parliament and the courts. So basically, it's really to talk about the issues with the lawmaking bodies, right? The problems related with the lawmaking bodies within institutions which have the role or the function to create law or laws. So it will be parliament, but also the courts and different kinds of issues and problems related to these institutions in the Pacific generally. Okay. So, for example, in the parliament or legislature, we should look at the electoral processes, political party policies. If people, when they are they elected because of the policies or because of the reputation or because they have money? And when they are elected, are they really following the policies of the party, etc.? Consultation, we have mentioned this last week, that there's still some issues with the consultation. People are not consulted. Public is not, oftentimes, is not really consulted. It seems like there's some secret bill sometimes, okay? So they don't care about consultation. They work the bill behind closed doors, and even though the bills are very controversial on taxes, so you wonder how this can be adopted, can become law, actually. So basically, the processes are not really followed. And deliberation during lawmaking process, the debates. I mean, if you can, if you guys can hear some of the quality of debates during the parliament, it may be interesting to. It may be interesting if oftentimes the parliamentary debate should be higher than television, just to see. I mean, and it can be very useful, helpful, because people will know what kinds of people we are electing. And then there are also a number of problems related to the courts. Independence of the judiciary, are they really independent? The question is always there. They're receiving funds from the government, but they are required to be independent. But not only this, I mean, when you look at what's going on at the moment in Vanuatu and also in some parts of the Pacific, this issue of parliamentary secretary, I think I mentioned this during the last tutorial. Parliamentary secretary, I think in some of the countries it's fine, but in Vanuatu, it poses a problem of the, not directly the independence of the judiciary, but of the separation of powers, the independent, that each power should be separated from the other. So there's some issues also with the judiciary. You know, sometimes when there are interference of a political interference in the judiciary or islandism or bias, you know, sometimes it's happening also in the judiciary, biasness. The quality of justice and the many more related issues, you know, with regard to access to the judiciary, to the physical access to courts, and also it's expensive. It may be very expensive for many, many people. Okay, first of all, the legitimacy of the rule of law. What we need to understand is that sometimes it seems like the rule of law is not working very well as it should be because there is a lack of, in the belief in the legality or belief in the power of law, how the political world should operate or be understood. So, to put it simply, sometimes when we do not believe in the legality or when we do not believe in the power in place, we are reluctant. I mean, anyone will be reluctant to follow or to do what is required to do. So some people, they actually wrote about this, the legalism or legal ideology or legal culture, and they link this to the belief in the power of law, etc. So it seems like if people who are in the power or the authority in place, if we don't believe in these people or in the legal authority, it's actually a problem because we are not going to obey or we're not going to do what we really required to do. And sometimes, I mean, and the legitimacy of the rule of law or in the legality may come from different grounds. It may come from how people are elected. It may come from also the traditional authority. It may come from religious authority, right? I mean, we believe in the authority in place based on some grounds. But actually the question which should be asked is, are we believing more in state legal authority or in traditional authority or in charismatic authorities? Because, for example, if you believe more in traditional authority than the state or legal authority, there is a problem. Maybe because the state or legal authority, they really inspire respect or belief. All right? So this is some kind of really an introduction before we talk really about legitimacy of the rule of law in the Pacific, including the Constitution. So as I mentioned, sometimes the legitimacy may come from different grounds, including rational grounds, and sometimes it may be a habit. I mean, now democracy is based on the contract, social contract, developed in 16th century, by Rousseau, Locke, etc. And this is how our democracy functions. That we give the people give the power to the representatives, and it's like a contract. Through this contract, though not visible, through the election, we give the power to our representative to actually go in there, in the parliament, in the government, and do the job for us. So it's like we give them the power, we give them the right to do so. Okay, so we are talking about different grounds of authority. If you read one of the readings in the Topicite, you will see that Max Weber, he actually talks about 3 different grounds. Okay, first one is rational grounds. It's rational authority which equals legal authority within modern legal systems. Actually, it's the state, or it covers the values coming from the state legal system, and also the state itself. And another commentator, and also if you read the Topicite, you will see that Etzioni, one of the authors, Etzioni, he talked about the civil society. He said all the values coming from the state or the legal authority, they are the values of civil society. Okay? It's important to make this difference. They are the values of civil society. And all the values coming from traditional authority and charismatic authority, including religious authority, these are not the values of civil society, but they are values of good society. Okay? So Etzioni makes the difference between the values of the good society and the values of civil society. And there's a clash, actually. When you look at our customary system, collective rights, values, etc., and the state, the values protected or defended under the state or modern legal systems, they are actually, sometimes there may be clashes between these two, the values between these two societies. Okay, so rational grounds, they come from the state, and then traditional authority, as you know, from chiefs or our customary leaders. Traditional authority. Etzioni talks about the civil, good society. The legitimacy may also come from charismatic grounds. Sometimes we're following or we're really believing on what a charismatic leader can do. I mean, in Vanuatu, some of you may know, Ralph Regan Vanu is really a charismatic leader. And what the government has done actually is that sometimes when it comes to some controversial projects, controversial bills, etc., they're choosing Ralph to take the lead because they know he's going to convince the people. So sometimes they believe in the legitimacy of the thing, of the rule of law, etc. It may also comes from these charismatic grounds or charismatic leaders. And as I said, the values of the under the charismatic grounds, they are also linked to the values of the good society. Okay? Remember this. So, for example, if I mention Etzioni in the final exam and I said, I mean, it's just an example, but you should know that he talks about the theory of the values, different values, whether they are from court society or civil society. And he linked the values of the civil society to the state and values of the court society to customary leaders or customary system and charismatic leaders. If you go through the readings, I think there's somewhere in the readings, also read about this particular commentator, Bob Hughes, on legitimacy of the rule of law in the Pacific. He basically says that in the Pacific, the rational authority, I mean, you now know that rational authority comes from the state, right? Or the legal authority. He said rational authority in the Pacific is weak, not strong. Maybe this is one of the reasons why sometimes we believe more in customary leaders than the politicians. And also that the traditional and charismatic authority is strong. I mean, it may sound not important, but it may be sometimes it may be a strategy, very good strategy used by the governments on choosing who is going to take the lead. If it's charismatic or if it's also traditional. In some of the controversial, bills and projects, etc. And he also said that the fact that rational authority is not strong and traditional charismatic authority is strong, this actually undermines legalism in the Pacific. And by this, he means that there is a lack of debate and there is corruption, lack of political will to represent national interest in a number of areas. So, yes, I mean, have a look at the readings from this author, and I think it's interesting. So maybe the way forward will be to develop a Pacific jurisprudence in which traditional authority should be integrated with state authority. I mean, it's not a new proposal, but may still be interesting. I've mentioned this, that the legitimacy of the rule of law also is also linked to the idea of social contract. Social contract. We should, especially the politicians, should always remember that they're not going there for the self-interest. We, the people, we are putting them there. And there is a contract, though not visible. It's a fiction, but it's the idea, the whole idea behind any democracy. We are giving them our right to go in the parliament and represent our interest. But this is not happening most of the time. Politicians, when they go there because of the self-interest and because of the pocket, and they don't care. In Vanuatu sometimes it's just frustrating. So rational individuals, they give up their freedom in order to get benefits of political order. So yes, everyone knows about the social contract. Not a new idea, developed by the Rousseau, Locke, people in 1600. Okay, another commentator or author to look at, and he's also developing a theory about the legitimacy on constitutional assent. But not only about the Constitution, but also law generally. In the reading provided, in one of the quote, he said, from the standpoint of legal theory, the modern legal order can draw its legitimacy only from the idea of self-determination. Citizens should always be able to understand themselves as authors of the law, to which they are subject as addressees. So the power belongs to the people. Not only politicians, but also we individuals to understand this. And if we're not happy about politicians, on the next election, we should change them. So Graham Hassel, on his theory of legitimacy on constitutional assent, he said, legitimacy is the acceptance of the foundational principle of a state and the constitution of a state. A people who see its state and governments as having legitimacy have a sense of constitutional unity. And he sees also a number of weaknesses in the legitimacy of the law. So basically, he looks at the legitimacy of the law, particularly the Constitution, and it seems to him that our constitutions did not have the assent or the consent or the input of the people, or that not entirely. They may be, it may seem that our people participated or were consulted, but actually it was not entirely the assent or the consent of our people, actually. So he sees a weak initial contract, a social contract, in this idea that specific constitutions are not reflection of pre-existing social contract or social order, and also poor performance of law. The other idea he mentioned, he also sees the differences in the values we defended, and we all know this. The state we have, or the values defended by the state or legal authority are completely different than the collective values of our customary leaders and traditional authorities. And this doesn't help, actually, in the idea of the legitimacy sometimes of the rule of law. I will go to a specific example of the constitutional assent, and we will see the example of Samoa when the Constitution was established. When the Constitution was established. So you need to look at the committees, conventional or constitutional committees established to draft, for example, the Constitution, and to hear and go around the country or the islands to hear what people say or what people want for the new country. So have we really done this, or we basically try to take to also include the colonial power, the agents of the colonial power in the constitutional committees, and they direct us how to draft the Constitution? And if this is the case, then of course it lacks the assent of the people. I mean, there's a question of the assent of the people, or the wish, the will of the people. So we continue on Hassel's theory. He said, where there are concerns about the validity or fairness of the electoral system, the social contract is undermined. Where there are concerns about politicians not acting in accordance with policies they were elected for, social contract is undermined. Where external interest, this seems to happen so often, even though we are not realizing it really. When external interests are seen as driving local development, social contract between us and politicians may be undermined. And this creates a potentially dangerous environment of rule of law being undermined, social contract being undermined, legitimacy of the state being undermined, and maybe sometimes the only result or the possible solution out of this will be the coups. I don't know, maybe. If things are not working as they should, maybe this may be another option. So I mentioned that one of the idea of the important idea on the of Husserl, he said, really there is um, a lack of constitutional assent. He said the constitution of Pacific Islands were rarely found on consent by the people, right? The colonial authorities established expert commissions, etc. Sometimes there may be some attempts to consult the people. There may be some choices offered to the people. And they may also be lent of an aura of legitimacy to the Constitution, but it did not significantly influence the content of the Constitution. So it comes back to the idea that it seems like how our Constitution were established, there was no really the consent, or they did that the constitutional committees, they really didn't seek for the consent of the people. And that oftentimes the colonial power is involved in the whole process of adopting a new constitution. What do you guys think about this? Do you think it's true or it's true? I mean, maybe this is the reason why sometimes chief leaders they are not happy about how the state is functioning, or the chief leaders, they feel that they do not have enough power, or that the constitution, how the constitution is drafted and adopted, it doesn't really give so much power to the chiefs. But if you look at the situation before the independence, even before the colonial powers they came, the chiefs were the one who actually control the territory and have power and governance over the people on the territory. A quick example of this is actually Article 3 of the Constitutional Convention of Samoa. If you look at the membership of the Constitutional Convention, and you go to the last point here, it is also it also comprises 10 European members in addition to the 5 European elected members of the Legislative Assembly. I mean, why would we include Europeans in the Constitutional Commission or Constitutional Committees, etc.? I mean, it's an example, but if you go back to your state, go back to your how the constitution of your country was drafted, or even the whole process of the establishment of the committees, who are in the committees, the drafting of the constitution and the adoption of the constitution. And let me know if you think really that it's really about the consent of the people and there is no involvement of some external interest. So yes, this is some of the questions you may look at. And I mean, even when you look at the constitutional, how it is at the moment, and how the state is run, etc., sometimes there's a problem of the performance of law, including the constitution. So people from Fiji, they may go back to the constitution in 1997 and also the new one in 2013 and try to, identify whether really the people were consulted. How about the Vanuatu constitutional referendum? I mean, one of the things which is happening now, I talked about the parliamentary secretary. The system of parliamentary secretary in Vanuatu changes the nature of the parliamentary system in Vanuatu. And actually the Constitution, in one of the articles, it provides that when you want to change the nature of the parliamentary secretary, you need to go to referendum, consult the people. Actually, the current government, they changed the law And they put in place the parliamentary secretary without going to referendum. And recently, at the beginning of this month, the Court of Appeal stated that it was contrary to the Constitution, and the amendment should be regarded as null and void because it is unconstitutional. So it seems like there is also a problem with the performance of law. The law says one thing, and our governments, they act otherwise. They're doing another thing. So they're not even trying to, consult the people when it comes to change the nature of the parliamentary system in Vanuatu. Solomon Island Federal Constitution has an attempt to generate assent. Go back and see how the Solomon Island Federal Constitution is made, the process, etc. Whether some external interest or some external agencies or governments were involved, and how the people were consulted in this whole process. And let me know if you think the people, the voice of the people, and they were really consulted in the process, etc., etc. There's a good reading you can find, actually, the website interpeace.org. Interpeace is really a good website to check on if you were interested on the constitutional transition, constitutional questions around the globe. This website is interesting. So as I mentioned, not only about the Constitution, but also about the performance of law. And sometimes we forget, and politicians also, more than us, they forget that the power and the citizens, they should be authors of laws. They're the one who gives the power to the politicians. Sorry, this is not very clearly. But it's not very clear here. But it seems like, political parties, elections, executive, legislature, they're all interrelated, interlinked without people. But actually, the people should be the center of everything. Okay? We should be consulted, and our voice, our interests should be taken into consideration whenever it comes to, why is that moving? The adoption of the law. I already talked about this, the weak social contract. Some of the reasons why there is a weak social contract, or it seems that there is a weak social contract in the Pacific, is the difference or the clash between the values of good society and civil society. So the values of the state and the values of the traditional authorities or our customary system. Big man politics, when the politicians they are elected, they think that they are the power. I mean, they forget about the rest, and even they forget about the people. Also, the rationality policy, they don't seem to work following the policy of the parties or why they were elected for. I mean, how this is supposed to be is we should elect people based on the policies of the parties, not because of the people. And if they're not acting in accordance with the policy, we should challenge them, or we should sanction, give them make sure that they are not elected in the next election. And also, the social contract sometimes may be hindered by inadequate rules. We put in place sometimes the rules that really are not helping, all the idea of taking into consideration the interest of the people or to consult people all the time. Sometimes the process in place, including parliamentary standing orders, everything, there's still a lot of issues. There's still a lot of problems to be solved, actually, in terms of not only the process but also the rules. And sometimes rules in place are not really working well. So in this table, you may see the summary of the challenge that we may sometimes face in the Pacific, and then summary of recommendation. Some of the recommendation how we can try to fix the problem or the issue. Just a quick example: political stability, because of the fragmentation of the political parties. It seems like more and more political parties formed. And it is very difficult. The consequence of this is that it is very difficult to have a major party in the parliament forming the government, right? So when you have many small different parties in the government, this creates sometimes instability. So maybe, for example, maybe one of the recommendations should be that we should put limits on reasons for filing motion of no confidence, and also maybe there should be party discipline, financial penalties for crossing the floor. When you are tired of being in a party or because you want more power, you want to be a minister, then you cross the floor. You change the party and you go to another party. And this is happening oftentimes in the Pacific. So go through this table and see some of the challenges and some of the recommendations which may help, actually. So what we are trying to do now is that we look at Parliament and we go through some of the issues, probably main issues. There are more issues, but some of the issues we may face or we are still facing in the Pacific, in Vanuatu particularly. Issues with legislatures, parliamentary quality and accountability. I mentioned this since last week, that there is lack of quality in the debate, debating laws before the parliament. I don't have the answer, the solution to this, but I guess, yes, we need to put people who are knowledgeable about the issues, and also maybe some minimum educational background to make sure that they really participate in the debates and raise the quality of the debates before the parliament. When it comes to the powers of the parliamentarians, how the whole process of the parliament is working, we also need to look at the standing orders, right, of the parliament, to see how this works. And sometimes it's not. They still need. They may need amendments in some of the areas. Let's see, for example, the process of the first reading, second reading, and all different committees. It's not. There's still a lot of issues with this. Sometimes the law may be enacted very quickly, even only after the first reading. Of course, you need to look at the process in place, but sometimes there's still lack in this area. So that's why it's important to mention the idea of parliamentary standing orders. So you need to go through this and to see whether they need amendment. And apparently there's still there's still some issues with this. I mentioned the MP's educational qualifications as possible solution. At the moment, I cannot really think of any states which really has put this as a limitation for anyone to get into the parliament to be elected. And of course, there may be some other areas, but they need more. We need more research, actually. I already mentioned some of the issues we see here. I talked about them a number of times already. Parliamentarians should reflect the policies they were elected for. Is the current electoral system fair compared to other years? If not, then of course they maybe need to review, strengthen the electoral roll, review representative of parliamentary acts about offenses, petitions, etc. Some of the ideas to help in the work of the parliamentarians is that the Transparency International has proposed that there should be contracts between candidates and electorate, right? I mean, candidates who are going to be members of parliament and the people, or the people of the constituency. Of course, it's not going to be binding, but it will show a clear commitment that when you are elected, you should come and consult us in any, whenever there is a bill or whenever there is a government project going on, you need to come and hear what we have to say and take this to the parliament. I mean, it's an example, but this might be interesting. I mentioned this sometimes when even though there are some very sensitive bills or controversial bills, the parliamentarians or the legislature go ahead with the adoption of the bill. It seems like they don't really listen to the people. Very clear example. I mentioned this example in Vanuatu, amendment of the parliamentary. One of the act actually to include the appointment of the parliamentary secretaries by the government and also give them official salaries. It was very controversial, but the government just go ahead with this because they wanted to maintain stability in the government, and they were afraid that they may be overthrown actually. There's an issue of corruption as well, and for this, maybe we need to involve all the institutions, not only one, but really all the institutions fighting together against corruption. I mentioned this a number of times already, in the last semester about people who took the human rights. Remember that I sometimes talk about this idea of constituency development funds, and it's really a big thing in Solomon Islands, in Vanuatu as well, but to a lesser degree. In Solomon Islands, constituency development funds, people who are members of the parliament, they receive a lot of money, to millions. We're talking about millions to develop for the development in their constituencies. There's a law actually covering this, and I think it has been passed by the parliament. I mean, Solomon Island students will know better, but the problem with the constituency development fund is that they're actually managing, they are doing the administration work, they are authorizing expenses of the fund. These all, what they are doing, it's actually the function of the executive. It's not the function of the legislative. It's not the function of the members of parliament, actually. So it's completely contrary to the principle of separation of powers. I'm not saying it's unconstitutional, because the principle of separation of powers is not clearly provided for in the Constitution, but it is a fundamental principle on which any democracy is established. So this may be regarded as an unconstitutional. I mean, I'm wondering whether someone in Solomon Islands has challenged the constitutionality of the Constituency Development Fund's legislation, right? Um, I mean, and this is happening as well in Vanuatu, but we the money invested in there is actually not is very small. It's very little comparing to Solomon Islands. There are a number of other the issues. The other thing, and I think I mentioned this earlier, the other thing to consider is who is driving the changes, or who is proposing for the establishment of legislation or law. So it may be interesting. It may be interesting to go and see, for example, who is behind the idea of putting in place a legislation, taxes, law reform, etc., and or the amendment. Sometimes the legislature, the government, that's okay, it's fine. But sometimes it may be interesting to do more research. Sometimes there may be some group of women, for example, that's okay. But the idea is really to see whether there's no external interference, of the external governments, foreign governments, or some groups, NGO groups coming from different countries, because this may not serve the interest of the country, the interest of the society, but it may serve some other agendas actually, so it's important. I mentioned this. Sometimes some of the process in place, they are questionable. Sometimes they pass the laws in very short times. There are a number of committees in place, for example, to be involved. Sometimes it seems like they're not really involved. So it comes to the process before the parliament and also the rules of the standing orders of the parliament. Another thing to consider, sometimes there is an issue with voter education or people who are going to vote. I mean, for us, for you as law students, it's fine because you are knowledgeable. You know who is the right person to vote for, because he's going to take into consideration the interests of the public, etc. But some people in the islands, or some isolated rural areas, they have a very different conception of politics. So they will vote for someone because this someone is going to give them something. This, in exchange, it is a completely, it undermines all the idea of, why we should vote, etc. And some NGOs are helping to educate people, right? Here, in some other places, and in Fiji, if you look at the law in place, they now prohibit help from these NGOs to help people because they are afraid of the interference, right? For external elements or external NGOs, etc. So this is a question. What are we going to do? Some NGOs, they are funded by foreign governments and they want to help us in the education of the people, how to vote, why we should vote, etc. But at the same time, our government sometimes may stop this. So yes, you can analyze this and determine whether it's good or not. But of course there is a problem with this. People are going to vote as always, there's also another thing with regard to bribery and gift, etc. Sometimes, especially during election, and also especially during the election, whether this may be regarded, and even after, in terms of the when politicians or political parties want to form the government, sometimes they may give something in exchange to obtaining, try to get some other political parties to join them, and to what extent this should be regarded as bribery. And in Vanuatu, in 2014, a number of MPs, including the Prime Minister, they actually went to prison, actually, because of this. Okay, so this is about some issues with regard to the Parliament and legislature. Very quickly on the courts, and this is the last point I'm going to talk about. The courts, some issues about the courts. The courts, they act as check on the legislature and the executive. For example, in Solomon Islands, I think it was in 2016, the High Court of Solomon Islands ruled that the tax-free law passed by the MPs in Parliament is unconstitutional. And more example, even as I mentioned here recently, the court said that the parliamentary system is unconstitutional because it changes the nature of the parliamentary system in Vanuatu. So, I mean, what we need to know is that in relation to the separation of powers, there is also the idea of checks and balances. Legislature is a check on the executive, and the judiciary is a check on both of them, actually. So what they're doing here, in some of the examples I mentioned, is the check on the legislature and the executive. But there is still a question of proper court procedures not taken when passing legislation or even in parliament sitting. I get to give you an example on how far the court should interfere into parliamentary function or work. I mean, you should think about this. And actually, no one has done research into this. If some of you are interested in, parliamentary system and law, etc., you should think about this. The interference of the courts, or to what extent or how far the court should interfere in the process or in the work of the parliament. Okay? Give you an example. Very recently, when there is a debate in parliament about the passing of the amendment of the legislation to put in place the parliamentary secretary, the member of the opposition mentioned that it should be out of order. They should not discuss this. They should put this aside because there was already a case before the court. There was already a question before the court to look at the question of whether the parliamentary secretary system is constitutional. But the government, because they had the majority, they didn't listen. They didn't care, and they didn't listen to the opposition. They go ahead and vote and pass the amendment. So, I mean, this may be regarded in some ways. This may be regarded as as contravening or as a contempt of court, because there is something already before. There's a question already before the court. You should not decide. You should let court finish the process or take a decision, a final decision before you act on this or you take a decision on this. So, but they don't care about this, and the question also is whether the court should have done at that time, the Supreme Court, which is the highest court in Vanuatu, whether they should have done something, interfere, for example, in the parliament and say you should not vote or take any action on this because it is before the court at the moment. I mean, not many research done in this area, obviously, but I think it may be in terms of LLM research or even PhD research, it may be very interesting because one thing we already forget, we as in when we do research, is that for LLM research and PhD research, you should bring something completely new to the legal knowledge, right? I mean, if you were writing your thesis on something which is not new and there are a number of articles or a number of papers written already on it, and some of the solutions have been proposed, it's not, I mean, what are you going to bring as a new thing in the legal knowledge for masters, and even more for PhD, you really need to bring something new. Otherwise, it's not necessary. I mean, it's not important. Okay, so think about this. Okay, and then there's also the issue with the quality of justice. Just mentioning some of the examples in Vanuatu, the custom reconciliation in criminal matters, so reducing sentencing in the cases of rape. It's becoming a trend in Vanuatu. Courts more and more, they reduce sentences when it comes to rape. After appeal, they may reduce. They are taking into consideration a number of things, including whether customary apology or customary reconciliation has been made. So they are going to reduce substantially the sentencing. What do you guys, I mean, people who talk human rights with me, they really know about this because we've discussed a number of times. But for the new students, it poses some really some interesting legal questions. It's a law. Sometimes it's an amendment of the penal code, which provides for customary reconciliation. Here in Vanuatu, for example, sometimes it may be a new legislation. The interesting question is to ask whether these amendments or this law, these provisions which provide for this, whether they are constitutional or not. Because what about the right to justice for the victims, right? And especially will be girls and women. What we need to reconcile is that during the customary reconciliation, the families of the victims and the perpetrators, they don't consider the view. They don't even ask the victim if a customary reconciliation should be made. It's about the family, connecting the two families together, and they don't care about the victim, right? But I mean, I hope that someone in Vanuatu, and some in Vanuatu, I hope that I may do this, but I sometimes I don't have much time to do it. But I hope that someday someone will challenge the provision on this, because I think it's unconstitutional. Provision, which is an amendment to the penal code, provides for the customary reconciliation that sometimes the court should take into consideration the customary reconciliation to reduce the sentencing. But it's against the fundamental human rights of right to justice for victims. There are also a number of issues with the application of human rights conventions in the Pacific. Those who are doing international law with me, they know very well about this. Sometimes the courts in the Pacific, they do not comply, or they don't even, they refuse to apply conventions even though they have been ratified. Instead, they would prefer to apply customary values. I'm not saying it's not good. Sometimes maybe it's good, in consideration of the interest of the local communities, etc. Uh, customary rights of individuals. Sometimes custom may prevail, but in terms of the respecting and applying conventions, yes, there is a question to this. I already talked about the independence and also the quality. Very quickly on the court operations, the court system is inaccessible to many citizens in Vanuatu and also in some other countries. The citizens, they find it very hard to access courts financially because it's very expensive. I mean, the legal fees for lawyers, it's crazy. It's crazy. It's a lot of money. In some rural areas, there are no courts. The courts are not there. So it may be very difficult. So the only thing maybe for them would be to rely on customary leaders to solve the problems. There are also a number of pending cases. There are sometimes issues with provisions of legal provisions, code of conduct. I mean, there are many issues we don't really have time to talk about, but sometimes it's really maybe useful to go and do some further research on the issues we have in the Pacific. There are many delays in issuing decisions. In Vanuatu, you may go to your hearing and you may wait for 1 year before the decision comes out. What are they doing during the whole 1 year time? Maybe they're drinking kava or whatever, but I mean, it's a problem. It's really a problem. Delays in even listing cases for hearing. You may register your case and wait for months before it is actually listed for hearing. So it affects there's really a problem in the administration of the judiciary. And so it seems like people in the judiciary, including the legal profession, lawyers, they don't really know, or maybe they know, but they're not serious about the professional code of conduct. They have some codes in place and they really need to comply with these rules, but they haven't. I mean, sometimes there is supposed to be a hearing, but the lawyers are not there, or the public prosecutor is not there, or the judge is not there. I mean, I'm just mentioning some of the things to think about. But when you are a lawyer, you should comply with the rules of the conduct, professional conduct, and everything. Not attendance, errors in pleadings. My gosh, I mean, I'm a little bit pessimistic, but I mean, maybe it may help some of us. I'm pessimistic about the situation in Vanuatu. I think sometimes it's good that I don't go into detail. Absence of magistrate, absence of assessors, customary assessors. Failures of prosecution staff to attend court hearings, etc., etc. All right, so I leave this to you. I already talked about proper court procedures not taken in when passing legislation. Okay, so this is the end of the lecture. I'm going to put up an announcement very quickly on the groups for the position paper. So if you haven't done it, please forward me or come and see me, or put yourself in groups and try to let me know as soon as possible. And you need to start working on this. I mean, we start the presentation next week. Yes, next week. So, but listen to this. It doesn't need to be perfect. It's the first step of the first step of the activity. And you will receive feedback from me and from the students. And then you prepare you rely on the feedback to improve your position paper, and then you will submit a written version, right? So, I mean, you guys still have 1 week, right, to prepare the position paper. I think it's really enough. So yes, start to work on this. Choose a bill or a law to analyze, and then you follow the process or the procedure or the steps we've seen this last week. And yes, and that's it. Okay, one last thing very quickly. My goodness, I completely forgot to do the audio recording for online students. How come? I have the recording here. I mean, my recording device here. I don't know. It's okay. Maybe, hopefully the system, because I think they have a system here, lecture capture thing. Hopefully it works. But the problem is it takes some time actually. Okay, what I was going to say. So you guys, some of you may know David Naylor. Yes, he's from Australia. He was senior lecturer in Lau Kolo for a number of years, and then he left. He's now doing his PhD in ANU. So he's around here doing some field work for his research. He's doing a PhD on professional legal conduct or something. But it's he also worked for a number of years in Australia. I think for an organization, and he really knows very well the process, the parliamentary processes, etc. The failures, including failures of in the process, including our system in the Pacific, and he's here. So I'm going to talk to him. Hopefully, I mean, it depends on his time, etc. But I hope that he will give us a talk probably next week. I'll let you know. I'll put up an announcement about this. And I think what he has to to offer, or what he has to explain in his not only in his research but also with regard to his previous experience, employment experience. I think it's going to be very interesting. So if he's okay with this, probably next week during the lecture, he's going to give us a 1-hour talk, or maybe it's going to be during a seminar, staff student seminar thing. But I will figure out the details with him and I'll let you know. Okay? All right, guys. Thanks for coming, and see you next week. So remember to finalize your groups and really start working on your presentation. I'm going to finalize the groups. I mean, the ones I already received. And then I'll put up an order of presentation on Moodle. I'll post the order on Moodle, and I'll let you know in the announcement forum. So try to check regularly the announcement forum as well.